On the broadcast tonight, Decision Day. The Obama health care law is upheld by the Supreme Court, and it's the Chief Justice who tips the balance. It wasn't a surprise that the more liberal members of the court voted to uphold. It was a surprise that the Chief Justice of the court crossed over and joined them.
Chief Justice Roberts, plus the court's other conservatives, actually agreed that the law could not be justified as a use of the commerce power. But Roberts joined the court's liberals in upholding the law instead as a legitimate use of the congressional power to tax people who choose not to get health insurance. Because the Constitution permits such a tax, Roberts wrote, it is not our role to forbid it or to pass upon its wisdom or fairness. The key to the decision turned out to be the Chief Justice, a lifelong conservative appointed to the court by President George W. Bush.
And I'm getting sick and tired of people marveling at each other for their so-called intelligence when there isn't any. Wow, we didn't predict that. How many of you, when you considered every possibility here, you know what, I think the court's going to actually end up calling this a tax increase? Who in their right mind would think that? Who in their right mind would predict that as the ultimate way in which the case would be decided? Nobody. You've got the U.S. Congress passing a health care bill that is based on the Commerce Clause being stretched to now say that the government can mandate that we buy or not buy something. That is how this case was presented. It is how this case was argued. It is how this case was presented to the American public. It is how everybody thought this case was going to be decided. Every prediction under the sun, nobody predicted this. Nobody predicted this.
Welcome back to Hardball. Tomorrow is, of course, going to be a very dramatic day in Washington and across the country when the Supreme Court releases its decision on the fate of the president's signature legislative achievement, the Affordable Care Act.
I actually expect the court to uphold the mandate, and I would expect the Chief Justice to write an opinion, perhaps saying that the mandate isn't really a mandate at all, but a choice that people have, either to purchase health insurance or to pay more taxes so that there isn't as much free riding.
Thank you, Professor Laurence Tribe. It's an honor to have you on. We'll see if you're engaging in wishful thinking or brilliant clairvoyance in these words of yours tonight. Thank you, sir.
From healthcare and immigration to money and politics, the Supreme Court is certainly shaping a lot of the political debate. Joining me now, Laurence Tribe, a Harvard Law School professor.
I do think that the court will surprise a lot of people when it probably upholds the Affordable Care Act in an opinion by another former student of mine, Chief Justice Roberts.
You do think it's going to be upheld in its entirety?
I think it will be upheld in its entirety.
My ally is the Force, and a powerful ally it is. Through the Force, things you will see, other places, the future, difficult to see. Always emotion is the future.
Welcome, everyone. I'm Martha Minow. I'm the Dean at Harvard Law School. This is an amazing panel here to talk about what may be one of the most important public policy issues in the United States. And what's fascinating is it's also one of the most important constitutional issues. We are unbelievably lucky to have Larry Tribe, the author of the leading treatise most cited on constitutional law in the world, recently returned from Washington, D.C.
It's important to be clear about what the only seriously challenged provision of this act actually does. The challenged provision creates an economic incentive in the form of a $750 per year increase in the federal income tax liability of those who do not comply for individuals to purchase health insurance called minimum essential coverage if they have taxable income and are not covered already by Medicare, Medicaid, the military, or their employers. That's all it does.
Good evening, and welcome to tonight's special meeting of the Commonwealth Club of California.
There is nothing hidden about the fact that this bill operates entirely through increasing the income tax liability of people who don't purchase the insurance that's required. The primary issue raised by the Affordable Care Act is whether Congress's powers, for some reason, stop short of increasing the income tax liability of those who refuse to purchase health insurance to cover the years before age 65. That's exactly how the individual mandate works. It tells people who can afford to buy health insurance and are not otherwise covered that they must either buy it or pay a tax penalty that will help offset the added costs that such people's economic choices impose upon others. The surcharge is calculated as a percentage of household income. It's subject to a floor and to a cap. It isn't imposed on anyone who isn't required to file an income tax return for a given year. And it isn't nearly steep enough to be punitive. In fact, it was deliberately set low enough so that quite a few people would end up choosing to pay the tax rather than to purchase the insurance. The taxing power provides an additional and independent pillar to support the mandate as a device to simultaneously raise revenue for the general welfare and encourage conduct that Congress has ample power to encourage. Those who deny that Congress can invoke the taxing power along with the commerce power here have quite a burden to meet, given that the term tax appears some 40 times in the minimum coverage provision, so that those who say that nobody called it a tax just haven't read it. Core parts of it were placed in the Internal Revenue Code. The only enforcement mechanisms for the mandate involve the civil collection procedures of the tax code.
Good afternoon. I want to welcome you all to our fourth annual Rosencrantz debate.
So the Act's individual mandate is sustainable. It has a provision that operates simply through adjusting people's federal income tax liability. The fact that Congress has the power to prevent insurance companies from discriminating against people with pre-existing conditions and people with difficult medical histories is not in question. But when it exercises that power, it creates a problem for the insurance industry that it solves by broadening its base, by requiring individuals either to purchase insurance or pay a higher tax. As Judge Kavanaugh pointed out in his dissent in the D.C. Circuit on Tuesday, the alternative would be something that wouldn't really change the thing politically. He says it would be a minor tweak to the current statutory language that, in his view, would definitively establish the law's constitutionality under the taxing clause. And that is to make clear, as this law functionally does, but doesn't in so many words, that anyone who chooses not to purchase the mandated insurance and instead pays the tax penalty is not a lawbreaker, is acting lawfully. If that language were included in the law, Judge Kavanaugh says there is no doubt that it would be a valid exercise of the taxing power. So it seems to me that what is dressed up as a principled argument about limiting national power and preserving liberty and preserving state sovereignty is really the attempt to take advantage of a linguistic quirk in the law and not to point to any fundamental flaw in it. So happy Valentine's Day. So the question then becomes, what about the Affordable Care Act? Where does it fit within this constitutional framework? The most controversial provision is Part B, the purchase mandate, requiring everybody who wasn't otherwise covered by Medicare, Medicaid, the military, or an employer to purchase and maintain a specified minimum of health insurance coverage if they could afford the premium.
The only enforcement of that mandate, it was not that people were dragged into the insurance office. It's not that they were put in jail for not buying it. The only enforcement was your taxes are going to be adjusted upward by a certain amount, calculated as a percentage of household income, capped at the price of the foregone insurance coverage, assessed and collected through the civil enforcement mechanisms of the Internal Revenue Service. It was an obligation. If you didn't meet it, all that would happen to you is that you would have to pay a higher tax, but also you would be called a lawbreaker. Now, to some people, that matters. The first major victory that the opponents scored against the Affordable Care Act was one of characterization. A major lesson of thinking about the Constitution is that a lot turns on how you get people to think about something. They framed the issue as this is a law that imposes an obligation conditioned merely on existing. The only way you can avoid it is to go to the Cayman Islands or to Switzerland or commit suicide. Well, that's really not true. It is triggered by earning a bunch of money. You don't have to become one of the 1%, but you've got to earn enough money to be above the threshold. It is a law imposed as a regulation triggered by earning money. Point 18. Maybe this is just a tax adjustment. You'll see that in the blog post I wrote back last fall, I was saying this could be supported under the tax power. There are a lot of precedents saying that the tax power gives Congress the power to raise and support armies and do other things with taxes, even if it's not necessarily called a tax. But the real problem with using the taxing power to support this is the taxing power supports the tail but not the dog. That is, it supports the penalty but not the underlying obligation. The freestanding obligation of which you are in violation, even if you pay the tax, when you don't comply with the obligation to buy the policy, is hard to defend as an exercise of the taxing power. It is conceivable, nonetheless, that the U.S. Supreme Court could become the first court to uphold the Affordable Care Act under the taxing power. Every other court so far, including the ones that have upheld it under the Commerce Clause, has said it's not a legitimate exercise of the taxing power. What could the court do? What it could do is say, we have a duty not to gratuitously invalidate an act of Congress. We have a duty to interpret it in such a way as to support its constitutionality. How would it interpret this to make it a constitutional exercise of the taxing power? Well, it would say, we interpret it to mean that you are in compliance with the law as long as you pay the tax. We just eliminate one sentence. In fact, Kavanaugh, in his dissent from the D.C. Circuit, said it's a minor tweak in the law. That's all it would require to make it constitutional. It's sort of crazy to invalidate it because there's that little provision that says, well, you're a lawbreaker, although there are no penalties. And besides, isn't it crazy to say that if Congress has no power to do this, that it would have had the power to do this if it had made this additional change? Very hard to imagine. So it's possible if a court which wants to strike this down to establish a limit on federal power chooses to do so, it certainly can. But I think it would entail a kind of impractical exercise of judicial discretion.